Hi, Tony DeWitt here, Missouri Appellate Attorney and a guy who likes to make the law make sense on YouTube. Today we're going to look at the detective's testimony in the YNW Melly case. Stick around. So one of the things that makes trials boring for the people who have to sit in the jury box is that it doesn't come in the way it does on LA Law or Boston Legal or any other legal drama you want to pick. Law and Order, for example. It doesn't just come in with the judge making a snap ruling on evidence and things keep coming in or get thrown out. It doesn't work that way because there are always situations where you have to move you have to move the jury out of the room, and then you have to have an argument, and the judge has to consider, and sometimes the judge has to take a recess and go back and do some legal research on his own to make sure he gets the issues right. Well, all of this is like, can you imagine watching a long movie, a 2-hour-long movie, and you get 7 minutes into it, and there's a giant tiger coming after the hero, and all of a sudden it stops, and somebody says, "Okay, you've got to wait now for 35 minutes, and we'll come back and let you see the rest of it." You would lose interest in that pretty quickly, especially if you had to get up out of your seat and go into another room, and you couldn't discuss the movie with anybody else. And that's essentially the way it is with the jury. So then when you come back into the room, we're not talking about tigers anymore. We're in a completely different part of the jungle. And that is often the way it seems to jurors, because the prosecution will be going down one route, and all of a sudden the judge says no more on that, and you're stuck with where you're at. So when the jury comes back in, you have to regroup and start another thread in order to get the information into the jury. So I would really love to be able to put all of the argument about some of these evidentiary issues in front of you, but I have tried very carefully to select just a couple and give you a little bit of a flavor about what they're talking about. Some of them are really kind of silly. So we'll take a look at that, and we'll look at this detective's testimony, and I will try and explain a little bit more about what's going on. So let's take a look at the beginning here, where the state tries to basically tell the jury why they ought to believe this particular detective.
And Ms. Bradley, this is your next witness?
Yes, Detective Mark Moretti.
Raise your right hand for us.
Do you solemnly swear or affirm the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Please state your full legal name for the record.
Mark Moretti.
Spell your first and last name for the court report.
M-A-R-K-M-O-R-E-T-T.
Thank you.
Please have a seat, sir. That microphone in front of you only goes up or down. It doesn't move back and forth, all right?
Yes, Your Honor.
You ready to proceed?
Yes, Your Honor.
Counsel, you may.
Thank you. Good afternoon, Detective. How are you today?
Well, ma'am, thank you.
Where do you work?
City of Miramar,
How long have you worked for the City of Miramar?
20 years.
And what is your current assignment with the City of Miramar?
Homicide unit.
How long have you been in the homicide unit?
Since 2000, I started working in the homicide cases in about 2016.
I'm not going to make you listen to all the things this detective has done, including serving in the Air Force and the Coast Guard and all of that, because while it certainly builds some rapport with the jury, it would probably bore you to tears. These are the kinds of things, however, that states' attorneys do so that their witness will seem credible. And that's the entire purpose of this little exercise, to demonstrate how credible this witness really is.
Okay.
When you made contact with Mr. Henry, did you have any knowledge of the surveillance footage from the New Era studio that's been entered into evidence of State 7?
No, ma'am. At that point, I came into it blindly.
A very common defense theme in criminal cases is, well, the police just jump to conclusions. They they knew this guy was a rapper and they saw that he was black, and as a result, they concluded that he did it. And to a certain extent, I think sometimes those are legitimate inferences to draw from, especially if you look at Mark Furman's testimony in the OJ case. But be that as it may, what the prosecutor here is trying to do is establish that he did not believe that any of these people were suspects when he first met them.
So how did you treat Mr. Henry?
He was a victim of a crime.
So the ladies and gentlemen of the jury have already heard the statement that you took. During the course of that statement, what things in that Mr. Henry said started setting off a little bit of alarm bells for you?
The biggest thing is where the crime allegedly had occurred. We were being told it was on Miramar Parkway, and we just west of Southwest 160, as closer to 172, in that area there. But when we had the area walked out, we didn't find any shell casings, didn't find any shards of glass, and you're in a residential. Yes, there is businesses there, but on the south side is residential. As many bullet holes there was in that car. Initially, I think I saw at least 10, and we didn't get a single phone call.
This is a very good and well-practiced witness. He answers the question within a question. The question was, what did you see that set off alarm bells? And of course, what the state really wants is, why were you suspicious? And he explains, look, there's no glass, no shell casings, and I didn't get any calls from people who would have heard all the gunshots. Pretty convincing that perhaps the incident did not occur where the young defendants say that it did occur.
So when you were there on scene, did you look at the car that was out there? You said you saw at least 10 bullet holes?
Yes, ma'am.
Did you notice any damage to the rims or the tires of the vehicle?
No, ma'am.
Did Mr. Henry tell you about a side swiping of a curb?
He said that when a vehicle pulled up next to him and started shooting, he lowered his position in the vehicle for his safety, and he hit the curb. But there was some front end damage, but you could tell it was older front end damage.
Was that explained during the course of his statement? That's from the prior accident?
Yes, ma'am, I believe so.
In terms of the way you treated him, what were you taking into account?
He's a victim of a crime. And sometimes when you experience very traumatic situations, you're not going to remember everything. And it's understandable that you're going to be vague sometimes in your facts. And even if you're not from the area, you may be confused on the location. So our biggest thing was that we knew something happened. We knew it just didn't happen where they said it happened.
Why is it important for a law enforcement officer to know where something happened?
Well, we got an established venue, which has been for jurisdiction for us to investigate the crime.
Other than his constant, wandering back and forth in his chair, which I find a bit off-putting, he's doing a masterful job here, and her questions and his answers are designed to show how reasonable the police were in their investigation. And he's saying, look, I understand sometimes people don't remember everything. They've been through trauma. A lot of times when you've been through trauma, things kind of get out of order a little bit, And in other words, I wanted to give these guys the benefit of the doubt. I thought they were victims of the crime. And of course, that's not what they were, or at least that's what the state now says that's not what they were. So this is one of those situations where you have somebody who has been a witness before. He's very good at being a witness, and he comes off as reasonable, and he's not the kind of witness that you're going to be able to pick apart on his prejudice or bias against the defendant, because he's already stated, look, I just come in, I look at this cold, and I see what I see. So again, a very good job by the state here of getting this witness in last, because I do think he is tying up a lot of the loose ends in this case.
At the hospital, you mentioned that you didn't see civilians when you first got there.
Correct.
Were there any civilians that you made contact with before you left?
Yes.
And who would those be?
There was some of the victim's family there, some of the Phillips family.
No, neither victim has the last name Phillips. You'll have to identify who those.
The Phillips family was with Chris Thomas's family.
Okay.
There was also I didn't make contact with him. Detective Bertrand did. Trayvon Glass, Andrew, I forget his last name. He was there. I made contact with the defendant's mother, Jamie King.
Okay. And after you left the hospital and made contact with those individuals, did you do anything else other than writing your warrants and executing your warrant on the Great Chief?
No, ma'am.
There were a lot of evidentiary objections in the part of this trial right before the detectives started to testify. And one of those related to a video. And I have some video of that and how the judge reached his decision. So let's take a look at that.
There's also video number 1, 2, 3, 4. And in that video, Mr. Demons uses a pejorative term that I think it would be inflammatory, and on 403 grounds we would object. It refers to Caucasians as crackers.
So here's the video clip that the defense does not want to get played because it contains this word cracker. Listen.
Is very friends. My name is Melly, and I'm gonna turn myself in. But I'm in a suitcase because these crackers are harassing me. And I have to get on a private jet, and I don't want them to see me.
Okay. YNW Melly is a rapper, right? Rappers use language that, well, let's just say they concentrate a lot on certain words that might be considered racial pejoratives. And the idea that you are complaining about the word cracker, which I have to laugh. I mean, I'm an old guy, so when you call me a cracker, I think you're referring to the fact that I'm a little salty, you know? But I don't take personal offense at that, and I can't really think too many white people do. So I laugh because the guy's trying to keep it away from the jury, but what he really wants to have happen is he wants to have the whole video excluded. And in some respects, this is a little bit like urinating on a candle while your house is burning down. Given all of the other violent lyrics in some of these rap songs, the idea that you'd be afraid the jury might be offended by the word cracker is kind of ridiculous. As I told you before, a lot of the objections in this case have bordered on the frivolous, and frankly, this is one. But the judge is going to grant some relief here in one reason, and one reason only, and that's because he doesn't want to be reversed on appeal because it's not probative. And I don't think the word cracker is particularly probative in this particular case. I just still think it's absolutely hilarious that, you know, every other word begins with the letter F or the letter N in a lot of these songs, and you're complaining about cracker? Really? But let's see what the judge does with this. That's the important thing here.
I most of the jury regarding the last video where the pejorative terms used, crackers. Just go ahead and delete it, all right?
So the county's permission, and I can take out just that term?
Yep.
So the court ordered the state to remove the word cracker from the audio. Now, if the jury is paying close attention and can read lips, they might be able to figure out that he's saying that, but I can't imagine they would care that much, because what's really important here is he says he's going to turn himself in. And throughout the course of this, he has not exactly been consistent in his denials and that sort of thing. So again, based on the whole of the evidence, this information does seem to be probative, which means it has the capacity to prove that something happened. And we'll have to see whether or not it's useful to the jury or not. Another issue that came up was the use of video that is on a phone that the defendant denies belongs to him, but that has him doing a lot of things on the phone. Here was the state's response to their motion in limine to keep it out, and their objection based on relevance and on a particular provision of the Code of Federal Regulations. Let's listen to this.
Of the underage child that has to be kept under seal for that in the phone. But the state has selected 20 videos. I think we're down to, 25 videos. We're down to 24 to showing who is using the phone and operation on the phone.
I don't know the relevancy of that, and it's repetitious to the 525 photos that we went through in about 3 hours the other day, coming from reportedly his phone. I don't know why we have to go through all of this again. And there's also a short video of a little baby on there also. I don't know what the relevancy of any of this is. And if it is relevant, if she can't get it through the 525 pictures that we have to sift through, where she manually counted each one, I don't know what we're doing, Judge, quite honestly. So I would object on relevancy. Cumulative. These are fancy words for me now.
Yes, Your Honor, the state has to prove that the defendant was the one using the 772-713-9807 phone number. This is a short selection that is representative of the number of videos that are on there that show the defendant being the person using the phone. The defense has argued that it's not his phone in any way, shape, or form. So this is showing that there is no one else on there, and that even with photos and videos that show other people, for example, have the defendant using the cell phone to FaceTime and videotape a FaceTime of another individual. And then constantly showing the phone in the defendant's hand, sometimes reflected in some sunglasses or eyeglasses on screen.
I know counsel objected to on relevance grounds. I already breached that, and we crossed that bridge a while ago. I overruled that objection. But now there's another objection. It's cumulative. Haven't we seen this, these videos and pictures?
We have not. These are different ones from different time frames, showing that the defendant had exclusive control of this phone for all times relevant to this case.
Anything else?
There's one where there's a child on it, and I think it violates the children's, what is it?
Online Privacy Protection Act, which says children under the age of 13 cannot be filmed or published without the parents' consent.
Now, the court had already dealt with the relevance objection. It had already overruled that much earlier. But let's see how it reacts to this Code of Federal Regulations argument.
All right, let's get back on the record. The state of Florida versus Devon. President is the defendant, his counsel, the assistant state attorneys, juries, and the jury. Regarding the objection was posted about the child on the CFR, that objection noted. I've looked at the CFR question. I don't think it's applicable. The objection notes over here. All right, and
again, this is one of those cases, I think, where the objections dominate and try and keep out evidence that hurts their client. But at the end of the day, it's going to be the sum total of all of the evidence that comes in that weighs on the jury's mind and helps them determine whether or not this person is guilty or not guilty. At this point, I really don't have a feeling for that. I don't really have a good barometer to tell which way this trial is going. A lot of the media coverage has been favorable to the defendant, so we'll have to see how this goes. That's what I have for you today. Thank you so much for watching. I hope you have a marvelous day today, and if you have the opportunity, I hope you have had the chance to do something nice for someone today. Have a great day. Catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.